All right. So Chloe Walker joined Tahirih Justice Center in 2015. As a staff attorney, she represents adults and children who have survived sexual assault and need legal assistance to protect their safety. Legal services she provides includes preparing asylum applications, file petitions, U-Visa applications, and family law matters. Prior to Tahirih, she practiced family law at Gray, Reed, and McGraw, PC. She currently serves as the Houston area's elected representatives on the board of directors of the Texas chapter of the National Association of Social Workers. Chloe has traveled extensively, spent some time in Cuba, Guatemala, the Dominican Republic, and several countries throughout South America. All right, let's get started.
Good morning. Can you guys hear me? Okay, great. Thank you so much, Dahlia and CILA, for having me this morning. I'm really excited to be here. As Dahlia mentioned, I started working at Tahirih last year. So I'm practicing primarily immigration law, but before coming to Tahirih, I practiced family law here in Houston at a private law firm. So I'm excited to be here talking specifically about family law. And it sounds like it's very exciting that we have so many speakers from all over the state. Is everybody mostly in the room, I'm assuming, immigration attorneys, or are there any non-immigration attorneys here? Okay, great. So are y'all family law practitioners, or no? Okay, great. Well, so this presentation is basically designed to be a 101 to family law, covering all of Title V, which is quite a large topic to cover in 1 hour, but what I'm going to try and do is just give you the basics. There's going to be a lot of words on my PowerPoint, which I know is not what you're supposed to do, but I wanted you guys to have all of the information that you needed so you can refer back to it later. The outline that you guys received is basically, it's more than what's on the PowerPoint. I removed some of it, but the outline serves as basically a reference guide with citations for all the different topics and all the law I'm going to talk about today. So our family law courts, they're designed to protect children. They're designed to do what's in their best interest, and they are designed to give children a voice in our system. You guys as immigration attorneys, when you're in family law courts and practicing family law, you have a unique perspective because you have an understanding of how to protect children beyond our family law courts and our immigration system. Today I'm going to be presenting on the perspective of a family law practitioner that doesn't know anything about immigration, and that's not too hard for me because I'm brand new to immigration. But the purpose of doing that is to get an idea of maybe you'll see where there's maybe some conflicts or something that just stands out to you in terms of what the impact would be on the immigration side of things, and just to serve as sort of a further dialogue about how the immigration world and the family law world intersect or maybe in some ways conflict. Oh, I need the clicker. Here it is. Oops.
Try now.
Okay. Great. Okay. So like I mentioned, Title V of the Family Code is a huge topic. It's something that's normally covered over the course of 4 days at advanced family law or extensive training. So I'm going to just be covering the tip of the iceberg today. But as I said, I want you to walk away with the resources to know where you can look to find more information, a basic understanding of every topic, and I've included citations in the outline for everything so you can know where to go look in the family code. And I think there's going to be a question and answer session at the end of it. I'm going to refer all my questions to Angela Stout, who's speaking after me. She's a board certified family law attorney and knows way more than I do. Okay, so overview of what we're going to talk about today. Pleadings under Title V of the Family Code. And as I kind of go through most of the pleadings that are available under the Title V of the Family Code, I'm also going to insert some findings that might be relevant to the work that we do with abused, neglected, and abandoned children. So findings that might be relevant later on in an SIJ case. I'm going to briefly talk about parenting classes. It's something that as family law practitioners we forget about a lot of times, but is an important piece to many judges. I'm going to talk about service and waivers of service and international service and all those different topics. And also I'm going to talk a little bit about special appointments at the end. Okay, so where do you start? The best place to start is the family code. I have a copy of O'Connor's family code. It's obviously a really large statute, but this is the best place to go because Texas has really put most of what happens in family law court, all of the rules into the statute. So I have O'Connor's. There's one by Harry Tyndall that's also really good. The Texas, excuse me. The Texas Family Law Handbook. This is written by Randy Wilhite and Joe Jenkins, who are both family law practitioners here in Houston. It's a reference book that's done by topic, so really this is the first place I always look when I have a question about family law. It's got the statutes, it's got case law, it's got everything. It's a really good guide. The Texas Family Law Practice Manual. This is a resource that's available online. It's got practice notes and forms, which are like templates for all of the family law pleadings that you might need. In Texas, it's put together by a committee. It's put together by a committee of the State Bar, the Family Law section of the State Bar of Texas. Some of the best family law practitioners in Texas spend a lot of time every year putting together this manual and updating it on a regular basis every time the legislature changes. And like I said, those templates that you can use for pleadings are they're just something that you absolutely need if you're going to be practicing family law. And they do, if you work in a nonprofit, they do offer discounts for nonprofits that are serving those low-income folks that can't afford to hire an attorney. The next is called the Family Lawyer's Essential Toolkit. This is given out by the State Bar of Texas Family Law section. If you're a member, you get it free. I think it's like $10 more if you're not a member, but it's definitely worth becoming a member for. It's a quick guide to everything from child support, rights and duties, standard possession order. It's got evidentiary objections, presumptions. It's just like the best thing to have with you when you're sitting in court and you need a quick reference guide to most things. So, and then the last thing I wanted to mention was on Texas Bar CLE. They have an online library that basically has every CLE article for every CLE offered by the State Bar of Texas. If you become a member of the College of the State Bar, which is a program you can get, I think if you do 45 hours of CLE, then you get an entire 1-year subscription to the online library, and you can look at any article from any CLE that the State Bar of Texas has offered for free. So for example, all of the articles from Advanced Family Law every year are in there. So if you need a deeper understanding of a very specific issue, that's another great place to look that I go to all the time. And then you should always, wherever you're practicing, you should always make sure that you look at the local rules of whatever county that you're in to supplement your family code. Okay. I'm going to start off with just pleadings generally in Texas. So under the Texas Rules of Civil Procedure, we have pleadings are required to have fair notice, meaning that you have to have fair notice of the claims, defenses, and the relief sought. You also have to provide a specific statement under the Texas Rules of Civil Procedure about what you're asking, but that specificity is not required for family law. So basically what I'm trying to say here is that we don't put facts in family law pleadings. And there's actually a rule under the Family Code that the court shall strike an allegation of evidentiary fact from the pleadings on the motion of the party or of the court itself. So that's just something to keep in mind. And if there's not an opposing party that might not bring this up and might not try to strike your facts from your pleadings, then it might not be an issue. But just generally speaking, when we are submitting family law pleadings, we don't typically include facts. And the reason is that oftentimes our opposing counsel will ask us to take them out. And then there are some specific requirements for SAPSR pleadings, suit affecting the parent-child relationship, which we're going to talk a little bit more about. But I've just referenced the family code there where you can find them. Things like the name of the child and their date of birth and whether there's a protective order that's already in effect. Okay, so the suit affecting the parent-child relationship is what we're going to be spending the majority of this next 45 minutes talking about. And this is Title V of the Family Code. And it covers establishment of paternity, custody, which is rights and duties, decision-making power, possession and access, which is what we think of as visitation, child support and medical support, and modifications of any of those orders. That's not everything in the family in Title V, but that's what I'm going to be talking about today. And just, it's important to note that any and all issues that are in Title V of the Family Code could be required to be in your SAPSR order. So a lot of times if you go in, a judge is going to want you to include child support, include medical support if you're addressing possession and access or custody. So they're going to want you to address all of these issues instead of just doing them one at a time. And for example, if you have a divorce, they're going to require you to include all of the SAPSR issues in the divorce. So standing, there are some general rules in Title V for standing of any type of suit affecting the parent-child relationship. Persons that have standing include a parent, an alleged father, and we're going to talk a little bit more about all the different types of folks that can potentially be a father under Title V, a child, CPS, a licensed placing agency, and then these last two I'm going to talk a little bit more about, but someone who has actual care, control, and possession of the child, and a relative within the third degree of consanguinity. And there's also a specific statute, just so you know, for sibling standing, that just relates to possession and access. So it's not custody, decision-making rights over their sibling, but for example, if you have two siblings that are in foster care and they've been separated and they want to have access to see each other, a sibling can file a SAPSR for access to their sibling. Or if you have a sibling that's over 18, they can file for access to their sibling. Okay, so you might be presented with a situation where you have someone who is not necessarily a parent or one of those other list of folks that have standing under the Family Code, and you're trying to get custody rights, possession, access rights for this non-parent. And one of the ways that you can obtain standing for that person is under 102.0039, which is a provision for a person who has actual care, control, and possession of the child. It cannot be a foster parent, because there are separate provisions that are specific to foster parents. The non-parent must have this care, control, and possession for at least 6 months prior to the filing of the order. It doesn't have to be continuous and uninterrupted. So there's a ton of case law out there on what it means to have actual care, actual control, actual possession, the 6 month period, if you've gone back and forth between different places, what exactly counts. But just know that it doesn't have to be continuous and uninterrupted. But that 6 month period has to end at least 90 days before the filing, so it has to have been someone who had recently had care, control, and possession of the child. And you have to meet all three of those conditions. So it's a much higher burden to try and get standing for someone who's a non-parent, but it's definitely possible. And if you use the Texas Family Law Manual to try and research the case law and apply them to the facts of your case, then you may be able to get standing under this provision. And then another option for someone who's a non-parent, and this often comes up with step parents, is someone who's a relative within a third degree of consanguinity. So it can be a blood or an adoptive relative. It can be a sibling, a niece and nephew, aunt, uncle, grandparent, great-grandparent. And there's several different provisions that address this type of person that can have standing. If the parents are deceased, then this person can have standing. If the parents are not deceased, but they give consent, that also counts. But if you have a situation where the parents are still alive and a non-parent wants to step in and try and seek custody, you must show that the child's present circumstances would significantly impair the child's physical health or emotional development. And that is, you can only file an original suit for custody. You can't, in that situation, using that legal burden, file for just possession and access. So, yeah, I'll leave it at that. Okay, so that's kind of standing. Who can bring a suit? Once you do bring a suit, I'm tucking this parenting class in right here early at the beginning of the presentation because it's something that you should always do first thing when you have a client come in. The first thing you should do is give them a list of parenting classes for them to take, because they need to. It's a requirement under the Family Code. Different judges in different counties have different specific rules about parenting classes and whether they have to be in person or online or etc. But you should really not wait until the night before to have your client do a parenting class. So from the very beginning, make sure they know about it so that they can go ahead and get it done and show the court that they're, that they're willing to do this right from the beginning. Okay, the first type of case that I'm going to talk about under Title V is parentage, which is primarily establishment of paternity. And this should be, a SAPSER case that's incorporated into a divorce. That's a little more straightforward because there's a presumption of paternity there. But in any other situation where you have a parent filing a SAPSER, you should really be establishing the paternity. You should really be establishing paternity. So we're going to talk about how you do that and all the different kinds of ways to become a father. You have to have personal jurisdiction, which I'm going to talk a little bit more about that under child support, because there are some specific ways that are listed in the Family Code of how to obtain personal jurisdiction in a parentage case or in a child support case. Standing is pretty much the same as typical Title V cases, but something to note is that there is post-18 standing for establishment of paternity if there's a child that has no presumed, acknowledged, or adjudicated father, and it's only the child that has standing after they turn 18. And we're going to talk a little bit more about, on the next slide, about what a presumed, acknowledged, or adjudicated father is. Okay, so it's usually pretty clear, although getting a little bit more unclear these days on how to establish maternity. Who's the mom? Usually it's the person that gives birth to the child, but with some of our gestational agreements and other ways of having children these days, that issue has become a little more complicated, but I'm not going to talk about that today. What I'm going to talk about is how you establish paternity. Who is the father? And the definition of father under Title V is an unrebutted presumed father, an acknowledged father, an adjudicated father, or someone who has adopted the child. So who is a presumed father? It's not necessarily just the father that's on the birth certificate. There's actually, specific way. There's a definition in the Family Code of exactly who is a presumed father. It's a child. This is a really brief summary of it, but for the most part, it's a child who's born during marriage, and there's all different circumstances about, whether the child was born just before the marriage, just after the marriage, etc. But for the most part, so if you are married to the mother when the child is born, you are presumed to be the father, and you're going to have to overcome that presumption if you don't want to be the father, or if you're another person that wants to establish their paternity, you're going to have to overcome that presumption. Another way to become a presumed father is to continuously reside with the child for the first 2 years of their life and to hold yourself out as the father. So that's kind of where the birth certificate comes in sometimes, because holding yourself out as the father, evidence of that would be on the birth certificate, but it's not. Just because you're on the birth certificate doesn't mean you're the presumed father. Acknowledged father. You can also acknowledge your paternity. Oftentimes that's done after genetic testing is done to ensure that you are the father, but there is a form out there called the Acknowledgement of Paternity. It's not something that you can have people sign unless you're an authorized agency, like a hospital or the Attorney General, the Child Support Office of the Attorney General. But basically, it's a legally binding document that's very specific, that's signed by the mother and the father to acknowledge the father's paternity, and it has the binding effect of being legally adjudicated the father. The last type of father is an adjudicated father. So if you've been served and gone down to the courthouse or initiated your own suit, and a judge has said you are the father by court order, that's the last way to become a father. Statute of limitations. So if you are a presumed father, let's say that your wife gives birth to a child during your marriage, maybe you know from the beginning that it's not your child, that your wife had an affair, but you decide, I'm going to raise this child as my own. You only have 4 years to change your mind about that. So to file a suit, if you're the presumed father and you want to get out of it, you want to try and overcome that presumption, you only have 4 years from the birth of the child. If you sign one of those acknowledgments of paternity, the legally binding document, you only have until someone incorporates it into a court order to challenge it. So there are specific ways to rescind it under the family code, but it's much more difficult after someone, after the mom goes in and gets a child support order from the AG's office. If you are someone that is a collateral to an acknowledgement of paternity, so let's say mom's dating somebody and has a child who's biologically, maybe she had an affair with her boyfriend with another guy, but her boyfriend says, hey, I think I'm the dad, I'm going to sign this acknowledgement of paternity. Come to find out, other guy finds out he's the dad, he wants to challenge that acknowledgement of paternity. He has 4 years from the date it was signed to challenge it, if he wants to assert his paternity and say he's the dad. And then, like I said before, if you were the child and there was no presumed, adjudicated, or acknowledged father, then there is no statute of limitations. So even after you're an adult, you can file a suit to establish paternity. And there might be different reasons you want to do that. There's a statute of limitations for child support. I think it's 4 years from after you turn 18. So as an adult, if you want to go back and say, hey, like my dad really should have been paying me child support, and file a child support suit. If you want to just establish paternity for the purposes of inheritance and things like that, there's different reasons you might want to do that after you're 18. If you perhaps are trying to apply for a special immigrant juvenile status and you need an order after you're 18. Okay, custody is the next big piece of Title V. And when we talk about custody, the words that are used in the family code are conservatorship. And what we're really talking about when we talk about custody is decision-making rights. And so custody, it doesn't necessarily have to do with, many of our parents in Texas are sharing custody, they're sharing decision-making rights. And the decision-making rights that come into play and are listed out in the family code, but there's a presumption that parents are going to be joint managing conservators, so they're going to have joint custody over their children in Texas. And the only way to overcome that presumption is, there's several ways that you can overcome that presumption, which we're going to talk about in a little bit, but just know that baseline, we're talking about joint custody, joint decision-making rights. And those rights are specified in Chapter 151 of the Family Code, and there are things like who has the right to designate for the primary residence of the child. So when you think of someone as having custody, they probably are the primary parent, meaning that they have the right to designate where the child lives. The child's going to be with them most of the time, although depending on what possession and access the other parent has, it might be something closer to 50-50. But when we're talking about custody, we're talking about who gets to decide where the child lives, who gets to make their educational decisions, who gets to decide if they're going to go to public school or private school, or if they need tutoring or some sort of special program within their school. Who gets to make invasive medical decisions, so not just who gets to take them to the doctor for their yearly checkups, but if it's a small child and they need to get the tubes in their ears or something like that, who gets to decide whether the child is going to have that surgery? And there are several others, but those are the big ones. And the court or the parties by agreement are going to decide if they want to make those decisions jointly. So we have to agree on whether or not the child is going to have that surgery independently. So either one of us can decide without, I might have to talk to the other party, but if I want to do it and the child's in my possession, I'm just going to go do it. Or the exclusive right. So only one parent gets to make that decision. And so, like, for example, with residency, that's usually going to be an exclusive right to one parent. A sole managing conservator is someone who has the exclusive right to make all of those major decisions. And there is a legal burden that you have to meet to prove that someone should be the sole managing conservator, which I'm going to talk about in a second. But just know that just because someone is the sole managing conservator doesn't mean that the other parent has no access to the child. The other parent's still going to have possession and access unless it's proved that they shouldn't. And they're still going to have certain rights that are available to all parents that are listed in the family code. They're still going to have the right to go to school activities, to call the school and know what grades the child has. Even if they can't make the medical decisions, they can still call the doctor and find out, the child's health, that kind of thing. So sole managing conservatorship is exclusive decision-making right for all those major decisions, but it doesn't deny, it's not termination of the other parent's rights. How many do I have time? Oh, halfway through, perfect. Okay, so findings of abuse, neglect, and abandonment or similar basis. So as I go up throughout this presentation, I'm going to try and tuck in some different findings that you might find applicable in your immigration practice. And there are a lot of relevant findings under custody in the family code. And I haven't listed all of them on the PowerPoint, but I have listed a bunch on the outline. So if you ever need a reference, you can just go there. But for example, the court finds that appointing respondent joint managing conservator is not appropriate because the court finds credible evidence of a history or pattern of past or present child neglect, physical or sexual abuse by respondent directed against the child. So this is the legal burden to overcome the presumption that both parents should be joint managing conservators. It's a finding in the family code that's designed to protect a child who's been neglected or abused, so that parent doesn't have those decision-making rights over the child. Another example. The court finds that the presumption that the respondent would be appointed joint managing conservatorship is rebutted because the appointment would significantly impair the child's physical health or emotional development. And I've put a definition up there from the family code about what danger to the physical health or safety of the child is. So again, there are many ways that you can overcome the presumption of joint managing conservatorship. These are just two of them that might be relevant when we have an abused or neglected child. Okay. The court finds that the presumption that this one right here is for non-parents. So if you have a non-parent that's coming in and wants to overcome that presumption, there's a presumption that parents should have custody, right? And so if you want to overcome that and say, I'm a non-parent, but I think I should have custody, here's an example of a statute you would use to overcome that parental presumption. So the court finds that the presumption that the parent respondent should be appointed or retained as the managing conservator is rebutted because the court finds that the parent has voluntarily relinquished actual care, control, and possession of the child to a non-parent for a period of 1 year or more, a portion of which was within 90 days preceding the date of intervention. And the appointment of this non-parent would be in the best interest of the child. And then the last one I've pulled is from the international abduction statute in the family code. There are some protections in the family code to prevent the international abduction of children. So if one parent has a connection to a foreign country and there is evidence of a risk that parent is going to flee the United States and take the child to that country, there are some protections. So this statute refers to international abduction. The court finds, oh no it doesn't, that's the next one, sorry. This is grandparents. The court finds that the presumption that a parent respondent will act in the best interest of the respondent's child is overcome because the denial of possession or access to a grandparent would significantly impair their physical health or emotional well-being. So if you're a grandparent and you want to come in and this is actually under the possession statute. But just again, another finding that you can use. This is the international abduction statute. So the court finds it necessary to appoint petitioner as the sole managing conservator because of the risk of international abduction of the child by the respondent. And there is a list of what is considered evidence of a risk of international abduction. So a history of domestic violence is one of those, as well as a tie to a foreign country that poses a risk that the child's physical health or safety would be endangered because of the specific circumstances of that country. So if there are country conditions, laws in that country, arranged marriages, human rights violations, that can be considered and whether there's a risk of a parent taking a child to that country. So there's a wealth of findings under custody in the family code that might be applicable to some of our cases. Okay, so the next big chunk of Title V is possession and access. And this is what we typically think of as like visitation. The right to possession and access of a child if you're not the primary parent or if you're not the sole managing preserver. So there's something called the standard possession order, which I'm sure some of you guys are familiar with. And there's a rebuttable presumption in the family code that the standard possession order is in the best interest of the child, that it's going to provide reasonable contact between the child and that non-primary parent or that possessory conservator that's not the sole managing conservator. And just to briefly just talk about what the SPO is, it's the first, it's applicable for children over 3. So if they're under 3, you can come up with something modified. But it's the first, 3rd, and 5th weekend of every month. Each parent gets an extended period over the summer. You alternate holidays. If you got Christmas this year, you'll get Christmas next year. Whoever gets Christmas, the other parent gets Thanksgiving, that kind of thing. And then I put a link that is in your outlines as well. But the Office of the Attorney General, the Child Support Division, they have this like sticker calendar that's really designed for kids to help them understand when they're with each parent. But it's really helpful in terms of understanding what the 1st, 3rd, and 5th weekend is, because it sounds really straightforward, but there are lots of fights out there about who has possession when. So if you kind of just want a brief guide to the standard possession order, they update it every year. So it's literally a calendar that shows you what the 1st, 3rd, and 5th weekend are. And then there's also an attorney in the Houston area that has links to all of the Houston area school districts, because the holidays in the family code are based on the school district of where the child lives. So if you want to know, if a weekend is extended because of the school holiday, then you need to go to the school district website, and this link here has a link to all, and so that's specific to Houston, sorry, but wherever you live, make sure you're looking up the school district of the child. So that was a standard possession order if parents live within 100 miles of each other. If they live over 100 miles, it's basically the same thing, but the non-primary parent can opt to just pick 1 weekend a month, with advance notice. If they don't want to do the 1st, 3rd, and 5th, they can say, I'm going to fly in from another state, and I want to pick which weekend it is every month. You get more time over the summer, the non-primary gets every spring break, and you still alternate holidays. As I mentioned before, there's another, if the children are under 3, if it's a baby, it's an infant, maybe it's not going to be in their best interest to spend an entire weekend with the non-primary parent if they're breastfeeding or have a certain sleep schedule they need to stick to. So for children under 3, you can come up with an alternate standard possession order. You can also, there's some elections that are available in the family code if you want to change the start times of the standard possession order. Usually they're at 6 p.m. If you want to be able to pick up the child from school and bring them back to school, you can elect to do that. And then there are some general terms for possession and access under the family code, which is basically who picks up the child who picks up the child where, which the language is really unclear to me, but for the most part, the non-primary parent picks up the child at primary's house at the beginning, and then primary parent has to go to non-primary's house to pick up the child at the end. If the non-primary moves out of the county, then that doesn't happen. They have to bring them back to the mom's house, for example. But anyways, just know that our family code is very, very specific with regards to possession and access, so that it's enforceable. But it can get really complicated and hard to understand. Okay, so what findings are available under possession and access to protect children who've been abused, neglected, or abandoned? Tying in with that, overcoming that presumption of joint managing conservatorship, you can also find that possession and access between the respondent and the child should be limited because of family violence or sexual abuse. And I've provided the definition of family violence up there from Chapter 71, which is the protective order chapter. But basically, if you've overcome that presumption to show that you should be the sole managing conservator, maybe there's also a risk that there's some abuse with the child. Not always. Sometimes if there's a domestic violence relationship, it's just between the parents, and we know that can impact children, but sometimes the courts are going to say, there's not actually an abusive relationship between the parent and the child, so they're going to have to be able to have unsupervised possession and access. But if you can prove that, that the child is in danger, then the court may require possession access to be supervised. Supervised by maybe a trusted relative or a trusted friend, or supervised through a supervision program. So the parent's going to have to show up at the offices of this program and exercise visitation with their child there. Or if they go out and about, they're going to have to pay someone to supervise them to be out and about. Similar, it's not in the best interest of the child to have unsupervised visitation because of child neglect, physical or sexual abuse. And there's also a piece in the international abduction statute that has to do with possession and access. So the court can find that it's necessary to require supervised visitation of the respondent because of the risk of international abduction. So the court thinks that it's such a high risk that we're not even going to let respondent have unsupervised access to the child because they may flee during that period of possession. Okay, child support. Typically in every suit affecting the parent-child relationship, if you're asking for custody, then you're typically going to be asking for child support too, and a lot of courts won't let you enter an order if there's not some provision in place for the support of the child. And here's that jurisdiction statute I was talking about earlier with regards to parentage. Beyond, the rules that we learned about personal jurisdiction and civil procedure, there's some specific instances where Texas says that there is personal jurisdiction. If they were served within Texas, if the dad ever lived in Texas with the child, even if they're living out of Texas now, if they were living in Texas, I'm just going to use dad. If dad was living in Texas and maybe wasn't living with mom and the child, but he was providing some sort of prenatal or postnatal support to the child, if he had sex here in Texas and there's a probability that that child was, resulted from sexual intercourse in Texas, then that's gives you personal jurisdiction. And we have something called a paternity registry, which you can, if you think that you might be the father of a child, you can go ahead and register in the paternity registry. So that if once the child is born and maybe, for example, the mom is, this usually comes up in the context of termination. So if you give birth to a child and mom wants to put the child up for adoption, if you've registered in the paternity registry, they have to check that first and give you notice that that's going to happen. Okay, so the court can order either or both parents to pay child support. If the child is placed with the primary parent, typically the non-primary parent is going to be paying child support, but they can also order parents to pay child support if they're in CPS custody. You can even be ordered to pay child support as a parent after your parental rights have been terminated. And child support lasts until the child turns 18 or graduates from high school, whichever is later. Or earlier than 18 if they're emancipated or they get married or they die. There's no time limitation on child support if it's a disabled child, so long as you can prove that the child still has a disability, the non-primary parent or whoever's ordered to pay child support can be ordered to continue to pay child support past 18. And typically, child support is going to be a monthly payment from one parent to the other, but you can also do, in the context of a divorce, if you're dividing your property and you just want to give a lump sum of money to the other parent, that can count as child support. You can purchase an annuity or set aside some other form of property for child support. But typically, in a typical case, it's going to be one parent is ordered to pay the other parent child support on the first day of the month in this amount. And it always goes through the state disbursement unit, which is the Attorney General's office, the Child Support Division. The obligor, the person paying, pays the state, and the state pays the obligee. And the reason they do that is so that there is a record of who has paid what when. It just makes it a lot easier to enforce child support. And there's language in our orders that says if you don't make a payment through the state disbursement unit, it doesn't count. So even if you have a parent that's just been writing checks or paying cash on the side, it doesn't count unless the person receiving the money decides to be nice and say, okay, that counts. But it's really best to do it all through the state disbursement unit so there's a clear record of who has paid what when. Okay, so how do we calculate child support. We have really specific guidelines set out in the family code of exactly how child support should be calculated. And there's a presumption, again, that using the guidelines, if you use the guidelines to calculate child support, that's going to be reasonable and that's going to be in the best interest of the child. And this is where the toolkit really comes into hand, because there's a whole tab on child support that has a tax chart. It has the chart of how the percentages you use for how many children are before the court and how many are not. It's really helpful. But child support is going to be based on the obligor's net monthly income. And I'm not going to go into the precise calculations of how to do that, but if you want, I've written a paper for Houston Volunteer Lawyers on child support. If you want that, I'm happy to send it to you. And there's a Prezi floating out there somewhere with a step-by-step example of how to calculate it. But something to know is that you are required under the family code to produce tax returns for the past 2 years, to provide a financial information statement, which is basically like a budget of all your money and where it comes from and all your expenses every month, what liquid assets you have, what non-liquid assets you have. And the obligor is also required to provide current pay stubs. So, I mean, it can be really hard to calculate child support if you don't know how much the other person makes, but under the family code, they're required to provide that information to you so that you can calculate it. And then if there's no evidence of income, there's a minimum wage presumption. So if there's no way to prove how much the other person makes, or if they are unemployed or saying they're unemployed, then you use the minimum wage presumption, which right now is $1,119 in net monthly income. So you would apply whatever percentage for however many children to that monthly amount. There's a percentage that you apply based on how many kids. So if there's one kid before the court, it's going to be 20%. If the obligor has children with somebody else, he's also going to get credit for that. So I think if you have one child before the court and another child outside the court, I think it's 17.5%. Anyway, so you use that little chart in the toolkit to help you calculate what percentage to use. And then something else to note is that it only applies to the first $8,550 of your income. So if obligor is making millions of dollars, technically under the guideline, you max out at $8,550 in net monthly income. The court can also take into consider whether somebody is intentionally unemployed. So if they're intentionally unemployed to try and avoid child support, then you can provide proof of that, and the court may base child support on their potential to earn rather than their actual earnings. Self-employment income is also addressed under the family code. It's really hard, if you have someone that's self-employed, it's really, really hard to prove how much they actually make, because you're going to be basing it on their tax return. And a lot of times when they're using the net of their income minus their expenses. So a lot of times on a tax return, it's really going to come out to less than what they actually make. But unless you just do a lot of discovery, it's going to be really hard to prove what they actually make. And something else important to note is it's not conditioned on possession and access. So even if mom isn't giving dad access to the children and not following the court order, dad still has that obligation to pay child support, and it can be enforced. Something else to point out is that, so those are the guidelines, but you can also request more child support than what's provided for in the guidelines, but there are certain factors in the family code that you have to refer to seek above guideline child support, and I've listed some of them here. Age and needs of the child, amount and time of possession and access. So if maybe dad is entitled to a standard possession order under the order, but he's not exercising it. So maybe he's only seeing the children 2 days every month, which means that mom, is caring for them the other 28 days of the month and is having to feed them breakfast, lunch, and dinner, provide more clothing, et cetera, et cetera. So she's actually having to take on a bigger financial burden because dad is not exercising his possession and access. So that can be a reason to ask for above guideline child support. If there are special extraordinary expenses, and then, of course, always any other reason consistent with the best interest of the child. So it can be tough to get above guideline child support, but just know that it's out there as an option. You can also get retroactive child support. So especially in the instance where, oh, thanks. Is that it?
Yeah.
Thank you. So retroactive child support. So if you just established the paternity of dad, maybe the child's 2 years old, and dad's known this whole time that he was the father, but he hasn't been providing any financial support. But mom, for one reason or another, waits for a couple of years to go in and try and get an order. She can actually ask for retroactive child support. It's completely discretionary, but you have to provide evidence that the obligor, whether the dad knew that he was the dad or he knew that he was probably the dad. The court will also take into consideration whether it be an undue financial hardship to him, and whether he actually provided any support during that time. But there's a presumption that you can go back 4 years on retroactive child support, and you can go back even further if the father knew that he was the father and should have supported the child, but intentionally did not support the child. So in some instances, while you're asking for child support going forward, you can also ask for retroactive child support. And there's also provision in the Family Code to provide for support for prenatal and postnatal expenses. Okay, an over 18 suit for child support. So as we mentioned before, the jurisdiction for child support can go beyond the age of 18 years old if the child is enrolled in high school and complying with the relevant minimum attendance requirements. So there's more specific language in the Family Code about what it means to be enrolled in high school. It doesn't just have to be public high school. I think it can also be a GED program. But if they are still enrolled in high school, you can seek child support until the last month that they are enrolled in high school. And then I have some case law up here because how do you prove that the child's enrolled in high school, and does it matter if they're going to class every day, if they're showing up, or if they've got kind of a large absence record? Well, there's a case out there that says that a report card just showing absences is not enough to prove that they're not enrolled. Like maybe they've missed, I don't even know what the requirements are, but say that you're only allowed to miss 15 days of school and they've missed 20. That itself is not evidence that they're not meeting the minimum requirements, because you have to prove, maybe some of those were excused because they've been in appointments with their immigration attorney or things like that. So just something to keep in mind if someone's trying to contest whether there's actually jurisdiction over 18. And that suit can actually be filed by the child. Okay, medical support. Every SAPSER order is also going to include provisions for medical support of the child. And this is in addition to child support, but the court treats it just like child support in the sense that it can be enforced as child support. And it's presumed that the obligor, the person who's paying child support, is also going to provide health insurance. But the court wants to ensure that there is health insurance available to the child that's reasonable. There's a definition for reasonable cost that I can't remember off the top of my head. But if it's available at a reasonable cost to either of the parents, then the court's going to order one of the parents to pay. If it's the obligor, great, he's doing his duty to provide medical support. If it's the other parent who is able to provide health insurance, then obligor's got to pay cash medical support to that parent in addition to child support to cover the medical costs. So it's additional child support, and the Family Code says that they're taking that into consideration when they make the child support guidelines. So it's all a piece of the puzzle. And then there's also provisions in there that that you have to share information about the health insurance to the other parents, so whoever can take it about it. Okay, so some findings that are available to abused and neglected children under the child support statute. This is a little trickier because child support is really just based on guideline support, and you have to pay it regardless of whether you have possession and access to the child. So there's not really as many relevant findings, but one that might apply is the above guideline child support statute. So the court finds it would be in the best interest of the child to vary from the child support guidelines because of the additional expenses incurred by petitioner because of the neglect, abuse, or abandonment of the child. So you can kind of try and make a tie between the fact that one parent has maybe completely abandoned the child, is not providing any financial support. So that's really putting an additional financial burden on mom or whoever's caring for the children. And that's the reason that you are asking for more child support, above guideline child support. And also maybe under the retroactive statute, the court finds that the respondent knew or should have known he was the father and sought to avoid the establishment of the child support order for the child. So maybe some sort of tie to abandonment there as well. I've also just provided in the outline some definitions of abuse and neglect that are in the family code. I didn't talk about today chapter 261 and 262, which are the provisions on investigating child abuse and state involvement CPS cases. But in that section there are definitions of abuse and neglect. So abuse includes physical injury, mental or emotional injury, sexual abuse, sex trafficking. So, if you ever need to incorporate that, there are definitions available. Same for neglect. Failing to seek medical care, exposed to substantial risk of physical or mental harm. The full definitions are in your outline. And then abandoned. I looked through the family code to try and find definitions of abandoned. There is one definition under the UCCJEA, which is what Angela's going to be talking about. So it's not necessarily, that's the jurisdiction statute, so it doesn't necessarily fall super squarely within some of the other stuff we've talked about, but it's really one of the only places where there's a definition. And it means left without provision for reasonable and necessary care or supervision. And then there's a definition under the penal code as well for child abandonment. Leaving them in any place without providing reasonable and necessary care for the child, in case you ever need that definition. I also just wanted to address some of the case law that's out there on abandonment. I know that there was recently the Henry PMT case, which said that there was no abandonment of the child when a parent voluntarily relinquished care to the grandparents of the children. 5 minutes, all right. And I think I pulled that case because it was related to SIJ, but now I can't remember. But so basically they were saying that if they provided for the care of the child to someone they knew was going to care for them, that's not abandonment. And they're relying on this case, Hendricks v. Curry. But I also, just for reference, found another case that's out there, just for those of us that are not in Eastland, that actually found that Hendricks was superseded by statute because the definition of abandonment has changed since that case came out. So if you look at Emory RDS, it gives it's a situation where termination was allowed because mom voluntarily left the child alone in the possession of another non-parent, and that was considered abandonment for the purpose of termination. Oh man, thanks guys. I've got my cheat sheet up here, so. So sorry, so they're the cases that I was just referencing. Okay, modification, just really briefly, you can modify any of these orders using a material and substantial change in circumstances. Burden of proof, but also if a primary parent voluntarily relinquished care of the child to the other parent, that's also another reason for modification. So that might fall into something in your practice where you're trying to establish abandonment. Okay, just quickly, oh man, I'm like so behind. Okay, I just wanted to briefly note what I did not cover. I didn't cover temporary orders. I didn't cover enforcement. I didn't cover termination of parental rights or adoption. I didn't cover CPS cases or guardianship, and I didn't cover evidentiary burdens of proof and things like that, just so that you know that there's a lot more out there that hasn't been covered. Really briefly, I wanted to talk about service because in family court, service is required of the other party, the other parent, and typically it's done through personal service. We also have waiver of service. Just an important thing about waiver is that you can't have a waiver that was signed before the lawsuit was served, because the point is that you're supposed to be giving them a copy of the petition. And for international service, there's some recommendations on the State Department website that you're supposed to do it through the U.S. consulate, but I can't find any statutory authority that says that you have to go through the consulate as long as it's notarized, not by an attorney, not in the case. For international service, we have to use Hague, the Hague Service Convention if the country is a member of the Hague. So Mexico, for example, is a member of the Hague Service Convention. And if they're a member of the Hague, you have to go through the State Department. And you can only use substituted service or service by publication if you've attempted to do personal service through the State Department. And then there's also another international treaty out there that you have to comply with if the country is a member of that. For the most part, I think a lot of countries in Central America are not members of either of these service conventions, so you can use our regular service rules here. Substituted service, if you're unable to personally serve the party or serve them by mail, you can go to the court and ask for an order that's very specific to your case and get permission to serve in another way. So if you want to do DHL to Central America, that's not normally a way that we would serve somebody, but you can go to the court and say, hey, I've tried to serve this person. I have been unable to serve them. Can I please serve them through this other mechanism? And then you have to, once you get the order, you have to comply with it very specifically. Angela, do you mind if I go over a little bit?
Go for it.
Okay. And then the last piece is service by publication. So this is your last resort. If you've tried to personally serve, if you tried to do substituted service and it still didn't work, there was no way to reasonably serve them, then you can use service by publication. But it's really only best used when the identity of the other party is unknown or you do not know where that person is. And you should really do your due diligence to figure that out. Really try and find the person yourself before you ask for service by publication, because the court's going to appoint an ad litem attorney, and if that ad litem attorney is easily able to find that person, then you're gonna make it look like you were trying to avoid service. I know there is in Houston, again, sorry for those of you that are practicing in other places, but there might be similar things available in other cities. In Harris County, we have a pro bono ad litem list that's organized through ABDA. So if you have a situation where you need to do service by publication, but your client can't afford to pay an attorney to be that ad litem, then there is a pro bono ad litem list, folks that will serve as ad litems for free. And I think you can just go to the court and ask them to appoint someone from that list specifically. And then there's a case out there just to be aware of that service by publication in English in a Texas newspaper when the respondent is known to be in Mexico, so not a situation where the respondent is unknown, that does not comply with the Hague, so something to be aware of. Was I on the right slide that time? I wasn't, sorry, I'm behind again. Okay, I'm just really briefly going to talk about special appointments. Under the Family Code, there are certain appointments that can be made to protect the children or provide representation to the children. The first one is an attorney ad litem. The definition is there, but basically an attorney ad litem is someone who is representing the stated interests of the child. They are the child's attorney. An amicus attorney is someone that's appointed by the court to protect the child's best interests. So they are basically an arm of the court, and they are there not necessarily to tell the court what the child wants, but what they think is in the best interest of the court. And then a guardian ad litem is a person also to represent the best interests of the child. That's typically like a child advocate. It doesn't have to be an attorney. And sometimes an attorney will be appointed guardian ad litem and attorney ad litem, like in a CPS case. There are certain mandatory appointments of these of attorney ad litems, guardian ad litems, and amicuses under the Family Code. In a termination suit filed by CPS by the state, they're required to appoint a guardian ad litem and an attorney ad litem. And then there's some discretionary appointments, so it's within the discretion of the judge to determine whether or not to appoint an amicus attorney, for example. And they need to consider whether there's a determination of the best interest of the child. But they also need to consider, am I on the right slide? Yeah. Whether the ability of the parents to pay, and balancing that ability to pay with the needs of the child and the needs of the court. And then there are some prohibited appointments. You cannot appoint guardian ad litems in a private termination suit that's not in the CPS context. Okay, we made it. Oh no. Powers and duties, they're all listed in the Family Code. So if you're ever curious what the duty is of your attorney ad litem, your amicus attorney, or your guardian ad litem, The duties and responsibilities are all listed under these citations in the family code. Okay, I just wanted to briefly mention some other opportunities to get additional training in family law. Every year there's the Advanced Family Law CILA. This year it's in San Antonio. It's a 4-day conference that is just a really, every family law attorney that I know in Texas goes to the CILA every year because it's just really extensive and provides all the updates on everything that's going on in family law. There's a Family Law 101 day that's usually, I think, the Sunday before the conference. And then there's also a specific day that's focused on the child abuse workshop. So that's a great place to go. Houston Volunteer Lawyers has a Family Law 101 that's usually, I think, during Pro Bono Week in October. That's free if you take a pro bono case. It's also just a really good training. And then the HBA Family Law section has monthly lunches here in Houston, and probably other sections in different areas of Texas have similar ones that are just on a different topic every month. And we're actually presenting next week at HBA Family Law section on relief for immigrant children, so kind of covering special immigrant juvenile status for family law attorneys here in Houston. And then another good one is right here at South Texas College of Law. It's called Anatomy of a Family Law Case. I couldn't find the information for this year, but I hope they're doing it again. It's usually an annual training. And that's, I don't know, we talked about tip of the iceberg. I don't know if this is how you feel right now, but hopefully you have your outlines, you have your citations, and you can always feel free to reach out to me if you have questions about family law. So thanks so much for your time.
Okay, I hear that the people in the back of the room are freezing, so we'd ask them to turn on the air for you guys. I'm sorry, we're gonna take care of it. I have a couple of announcements.